Well, welcome everybody to another installment of our series on intellectual property, otherwise known as I Will Sit Through Anything for a Free Lunch. But today I'm going to talk about the four flavors of intellectual property. And we've talked about patents in the past, but and we'll talk about them again, but we'll talk about them really in the context of what other kinds of intellectual property rights are out there and how do these things all fit together. And I think that you'll find it's an interesting story. And it really starts with the general concept of intellectual property. Intellectual property is essentially something that man has created. We're creating it. We're saying that creations of our mind can be owned and can be treated like property, but it's intangible. And the value doesn't come from your ability to hold it, your ability to live in it like a house, your ability to drive it like a car, but it comes from your ability to do other things with these concepts, such as develop and sell products or protect your market for particular products. Ownership of intellectual property is completely a creation of law and public policy. And there was a big debate among the founding fathers about whether we should even have intellectual property rights in the U.S. or whether, as Thomas Jefferson urged, ideas should be the property of no man and should be free to all. But ultimately, luckily for us, Jefferson's initial views didn't win out. And the Constitution of the United States provides for intellectual property rights. Article 1, Section 8 says, Congress shall have the power to promote progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This was actually fairly revolutionary, and at the time, the only country in the world that had patent rights was England. The rest of the world had taken the Jefferson perspective. We have four different flavors of intellectual property rights that we're going to talk about today, some of which directly are addressed in the Constitution, which would include patents and copyrights. Patents covers compounds, machines, and processes for the most part, and gives you the right to the patent owner, the right to exclude others from making, using, selling, offering to sell, or importing into the United States the patented article, or the right to practice a patented process. Copyrights cover works of authorship that are reduced to a tangible form of expression, such as a sound recording, such as a book. And copyrights give the copyright owner the exclusive right to copy, distribute, perform, display, and make derivative works. We'll talk about these in more detail. And then there are some intellectual property protections that are a function not of state law or constitutional law, but are a function of, not a function of federal law or arising under the Constitution, but are arising under state law. And those would be trademarks and trade secrets. Actually, trademarks fall under both. Trademarks are protected under federal registration regime by the U.S. Patent and Trademark Office. But also there are state trademark rights as well, which we'll talk about. And trademarks indicate the source of goods and services and basically prevents others from selling products masquerading as products from your company or of your known brand. And then trade secrets are entirely an animal of state law, and they are essentially secrets that have commercial value because they're secret, and for someone to take your secrets and use them and improperly is unlawful. So if someone works for your company, they get secrets about how you make your products, and they go to work for a competitor and tell them how you make your products, that would be misappropriation, and you could sue them and the company for that. But let's start with patents, because in the context of academic tech transfer, these are certainly the main thing that we use. And there's a reason why patents are very important for academic tech transfer, and that is that they fit. They work well because patents are often described as a contract between the government and an inventor, where the government says, if you agree to tell the world about how your invention works, then the government will give you a period of time during which no one else can make, use, and sell your invention, and you'll be able to financially be rewarded for having created the invention. And the reason that this works for universities is because we tell everybody about how our inventions work anyway. And so this is a way for us to not only preserve our right to publish our research, but still protect the commercial value of that and use that commercial value as an incentive to encourage companies to take our inventions and turn them into products and services that can improve, for example, human health. Patents give you the right to exclude all others. It doesn't give you the right to actually do anything. It gives you the right to stop other people from doing things. So it gives you the right to stop other people from using your invention, but it doesn't really give you the right to use it yourself. So, for example, if you have a patent on making illegal drugs, I have a patent on a new method of making heroin, it doesn't mean that I can go out in my garage and start making heroin and selling it to people. Heroin is still a controlled substance, and I would wind up in jail. So, but if there was a company that was manufacturing narcotics for approved medicinal uses, for prescriptions, I could sue them for infringing my patent because I have the right to exclude others from using it. Or perhaps I could go into the legitimate manufacture of narcotics for medicinal use, and my patent would then serve as a shield around me to prevent others from doing what I'm doing. A patent is awarded only if an invention is found to be useful, and that's a fairly low bar. It has to be novel. That is, it has to not already be known in the world, and it has to be non-obvious to one of ordinary skill in the art. There has to be some leap of logic to get there. It can't be something that someone of ordinary ability in the field would naturally come to in trying to solve that particular problem. Patents expire 20 years after they were applied for, and a U.S. patent covers only the territory of the United States. So if you have a U.S. patent on, let's say, a new bicycle, nobody can make, use, sell, offer for sale, or import into the United States that bicycle. But they can go to Europe and they can make all the bicycles by your design they want and sell them as often as they want, unless, of course, you have patents in Europe. And you can get patents in pretty much any country in the world. Patents are more difficult to enforce in certain countries than in others, so that can be a challenge, and it can be expensive, but you can.
Would it be illegal to import them back into the United States?
Yes, because remember, your patent gives you the right to exclude others from importing into the United States the patented article. Now, there's also something called the Process Patent Act. What if you have a patent on a method of making a particular drug, and a company, but the drug is known. It's an old drug, but you have a patented method on a better way of making it. And your competitor sets up a factory in England. They're making the drug using your method, and then they're shipping it into the United States. And the Process Patent Act says that would also infringe your patent. If someone outside the United States uses a method that is patented in the United States and then imports that product into the United States, that also infringes your patent, which can be an important protection when you have method claims. Utility patents are pretty much what we're usually talking about. A utility patent protects any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. This comes from the United States Code 35, Section 101, which is USC 35 is where all the patent laws are located. A plant patent covers an asexually reproduced variety of a plant that is novel, distinct, and non-obvious. And the biggest area for plant patents is patents on the parent plants that are used to make hybrid varieties of crops. So you'll have a company like ConAgra may own patents on a particular female plant and a particular male plant. And those two plants can only be propagated by tissue culture, because what you want to do is then you use those two plants together to make a hybrid seed that has qualities that are better than the qualities of both parents. And hybrid crop varieties are of huge commercial value, and one of the reasons is you have to buy that seed every year. You can't just go through your fields and collect the seed that came off the plants that you planted last year, because they won't have those desirable qualities. Only the first generation hybrid seed will have that. And so that's a way for the hybrid seed companies to control the market and always have ready buyers for their products. Plant patents, by the way, if you ever have any doubt whether patents promote progress in science and the useful arts, prior to the Plant Patent Act, there was virtually zero commercial research on hybrid varieties or any kind of asexually reproduced plant whatsoever. And if you look at the number of plant patents, it just skyrocketed when the Plant Patent Act was passed. I think it was in the 1950s. And an entire industry of hybrid crop varieties was born from the Plant Patent Act. It's really a neat story. Design patents are kind of the opposite of utility patents. They're issued to cover original, novel, and non-obvious ornamental designs for articles of manufacture. And you have to disclaim any functional features. So, and one of the places you see design patents used a great deal is for tire treads. So if you look at the Patent Gazette, which comes out once a week and has summaries and drawings of every patent issued that week, there'll be pages and pages and pages of tire treads. And they get design patents on them because proving that this particular tire gets better traction than some other tire design would be expensive to do, and they don't really care. They just want to distinguish their tire from somebody else's tire. So they come up with a cool tread design, and they get a plant patent. They get a design patent, and no one else can make tires with that same tread design. And they can say our tires are superior, and so nobody can go and say, well, Michelin sells a lot of tires. Let's just copy their tire treads and say ours are the same as Michelin. Well, they can't do that because of these design patents. What's patentable? Here we're talking again primarily about utility patents. In the case Diamond v. Chakrabarty, which first ruled that living things are patentable, such as genetically engineered organisms, the court said anything under the sun made by the hands of man is patentable. So new chemicals, new drugs, new methods of making them, new uses for old drugs. Purified natural materials, such as pieces of DNA and purified enzymes, because they don't exist in nature in a purified form. So back in 1948, Rutgers got a patent on substantially purified streptomycin, which was the first antibiotic that ultimately eradicated tuberculosis. Streptomycin was secreted by the bacterium Streptomyces to defend itself against other bacteria, but it was the fact that Waxman had purified it and used it as a drug made it distinct from that which appeared in nature, which was in an unpurified form. New formulations, so you can get a patent on an improved shampoo or a new a metal alloy that has a certain composition of different metals in it. Transgenic animals or plants, you can't patent humans because the 13th Amendment to the Constitution abolished slavery. Methods of performing a particular function using computer software. Basically, you say, I have a general purpose computer, I feed it certain instructions, and now it becomes a special purpose computer, and I want a patent on that special purpose computer. And that's how you can claim computer software inventions. Methods of doing business. The Supreme Court recently said, yes, you can patent methods of doing business, but they have to be more than simply mental steps. It has to be more than simply a mathematical algorithm. And then tire tread patterns, and also clothing. You can get design patents on clothing, believe it or not. One area of commerce where there's very little intellectual property protection is in fashion design. But every once in a while, people will patent clothing if it has a particular functional feature. So, for example, if you look in the patent literature, you'll find all kinds of patents on aprons. Aprons having particular pockets made to hold particular things. You know, a sewing apron that has a special place for the scissors, and there are all kinds of articles of clothing. So if you search design patents, you'll see all kinds of interesting things.
Would that include materials like Gore-Tex and that type of thing? You know, composition, which is supposed to have certain qualities?
Right. You could patent the composition of matter of Gore-Tex, and I'm sure that they've made a lot of money off those patents. I knew a guy once who owned the company that makes Tupperware, and you know what they owned the patents on? Kevlar. They owned the patents on making bulletproof vests. Yeah, very odd combination of products, but still polymers. Right? Okay, how do you get a patent? Well, very often these days people will file a provisional patent application, which there are you have to meet the same requirements as you do in a regular patent application, but there are the formal requirements are relaxed. You don't have to have any particular format. You can kind of just cobble together some, for example, a scientific manuscript and some other things. You don't have to make it too fancy. And then you have 1 year. That basically provides you with a filing date for that 1 year, and within a year you then convert that into a formal patent application. And then that sits in the patent office for quite a while. When you get to 30 months from your provisional filing date, you now have to decide if you can file, when you convert it from the provisional, you can either just file it in the United States and just go after a U.S. patent, or you can file it under the Patent Cooperation Treaty, the PCT, which is an international application, and then you have until the 30th month to decide which countries you want to pursue that patent in. And when you decide to pursue whatever countries you decide to pursue it in, you're going to have to file a patent application in that country, and that's going to cost you even more money. And then when ultimately the patent office in 2 to 3 years might get around to looking at your patent application, and they will almost always reject it for a variety of reasons, and then you have 3 months to respond to them. But you can buy another 3 months of extension by paying extension of time fees. A patent examiner, when they first look at your patent application, they're looking to see whether you have a demonstrated utility. Is the utility that you've described one that one of ordinary skill in the art would believe? So if you say this is useful as a treatment for cancer, and you've provided some data to show that it kills cancer cells in vitro, well then one of ordinary skill in the art might believe that would have utility in treating cancer, so that would be sufficient. Is it novel? Now, novelty and non-obviousness are very simple to tell apart. The question about novelty is there one patent somewhere, one paper somewhere, one product brochure somewhere that if you pick it up and you read it, you go, oh my God, there's my invention in there. If that's, and it doesn't have to be a lot, it can be 3 sentences in a book. Oh my God, there's my invention. Yet you lack novelty, and you're not going to get your patent. On the other hand, non-obviousness is a question of not only is there one book or one paper, it's like, well, I found these 3 articles, and if somebody who was of an ordinary skill in this field read article number 1, article number 2, and article number 3, they would see, my invention would jump out at them. That then your invention is obvious to one of ordinary skill in the art, and it's not patentable. Needless to say, novelty is kind of a slam dunk. If your invention is not novel, if there's a reference that described your invention to a T, it's pretty much cut and dry. Non-obviousness is arguable. Yeah.
Novelty, what if it's your publication?
If it's your own publication, well, actually, if it's your own publication, if it was published more than a year before you filed your patent application, you're out of luck. So you have this 1-year grace period after you publish your own stuff that you can still get a U.S. patent. Unfortunately, there is no such grace period in any other countries. So if you publish something and then somebody comes up to you at a meeting and says, oh my God, I hope you patented that, you can still get a patent in the U.S., but you can't get a patent in any other country.
So what are the limitations on what qualifies as a publication?
Oh, good question.
The company is claiming that tablet computers were in 2001, a Space Odyssey, so therefore there's no novelty.
In the United States, a publication has to be a printed publication or patent anywhere in the world. But oral disclosure doesn't matter. So in the U.S., if you go and give it, what's that?
A peer-reviewed publication?
No. It can be any piece of paper that was distributed to a substantial number of people. If you give a talk at a conference, that's going to be, and you give handouts, those handouts are going to be considered a publication because you've given a written disclosure of your invention to a substantial number of people in your field. If you just go give a talk, you don't give any handouts, then that's not going to be a publication in the U.S. because it has to be written. The rest of the world considers that a publication. In fact, in the rest of the world, from the moment you utter your invention, it's not patentable. But in the United States, that doesn't count.
I see a lot more now at conferences. You present a poster and people will photograph your poster.
If you allow people to photograph your poster, it's going to be a publication.
And you're talking about talks in a meeting, but if you are a PowerPoint presentation with all the...
Yeah, PowerPoint presentation. Again, if it's a printed publication that's available to the public. If you give a talk and you put it on your website and people can download it, it's published. In fact, there's been a big question. What about somebody has a PhD thesis and they finish their degree, they take the thesis over to the graduate school takes it over, puts it in the library, puts it in the card catalog, today they just put it in their database, and nobody ever looked at it. It's still a publication. It's a publication from the moment they put it in the card catalog. Now, if you think that you have an invention and you or your graduate student wants to turn in their thesis, most universities today have a system where you can actually ask for your thesis to be put in a special collection that can only be reviewed upon your permission. Then it's not published until you actually give somebody that permission. So there's a lot of a lot of ins and outs about what constitutes a publication. There was a very famous case, I don't know if you remember, probably 10 years or so ago, Nabisco came out with these chocolate chip cookies that were soft. They kind of were like the cookies that just came out of the oven. Instead of being brittle, they were soft. The soft batch cookies, they called them. And General Foods said, wow, they're making a lot of money off these soft batch cookies. They started making them too. Well, Nabisco had a patent on the process for making these cookies, and they sued. It was a huge litigation. And one of the things that happens when there's a patent lawsuit is whoever is the accused infringer goes searching the globe for a publication that might get them off the hook. And in this case, General Foods found a 1952 cookbook in the German language that had a recipe for cookies that actually carried out the patented process. And they brought that into the courtroom, and that case was over in 5 minutes. One of the things that, the other thing is, if your invention lacks novelty, it's said to be anticipated. So this cookbook was an anticipating reference, and meaning that their process lacked novelty and the patent was declared invalid. Now, when you disclose, whether a disclosure or is a publication or not also depends upon whether what was published is enabling. That is, could somebody read what was in that article and actually carry out your invention? And sometimes your own publications, I had one case where that actually wound up, I was representing Johns Hopkins in a patent lawsuit when I was practicing law years ago, and there was an abstract that it was the patent was directed to antibodies to the CD34 antigen used to purify stem cells for doing bone marrow transplants. And they had printed an abstract in a proceedings that described the CD34 antigen and gave its molecular weight, and that would ordinarily kill your ability to patent that antigen or antibodies against it. But as luck would have it, the person the grad student who did the molecular weight determination used the wrong standards and got the molecular weight wrong in the abstract. And the molecular weight was actually 75,000 Daltons, and the abstract said 180,000 Daltons. And we convinced the court, and ultimately the other side, that anybody who tried to carry out the invention would go looking for 185,000 Dalton protein. They wouldn't be able to find it. So they couldn't carry out the invention, so that abstract was not enabling. So sometimes a terrible mistake can turn out to your advantage. And then you also, when you file a patent application, the examiner, you have to tell the examiner what's the best way of making and using your invention that you know of as of the time you filed your patent application. Now so if you file a patent application, you can't say, well, I'm going to hold back these special tricks because I don't want to tell people about that because that'll be my little secret, my trade secret. You can't do that. You have to tell them everything. On the other hand, after you file your patent application, then you will learn a much better way to make the invention. You don't have to go back and add that to your patent application. The only obligation is to describe the best mode at the time you made the invention. Okay, so eventually you debate back and forth with the patent examiner. You convince them your invention is useful, novel, and non-obvious, and you get your patent issued. How long does it last? Well, utility and plant patents last for 20 years after you filed for your application. So if it ends up taking 3 to 6 years for you to get your patent, then your patent's going to wind up lasting 14 to 17 years.
Is that for provisional
I know this is the regular, this is the patent after, so you file the provisional, then you turn it into a regular application. The first year is free, yeah. Although you don't actually have any protection until your patent issues. And that's part of the problem with method patents. So if I have a method of screening for drugs and I file a patent application on it, there's nothing to stop companies from using that method until the day my patent issues. And if it took me 4 years to get the patent, they've had 4 years to use my invention to discover new drugs before my patent issues. I may not be able to get any value out of it after that point. Now, your design patents, on the other hand, last 14 years from the time they issue. The process of getting a design patent is pretty straightforward, as long as your new apron has ornamental features that are different from the other aprons that have design patents. You'll get your patent issue pretty quickly, and you get your 14 years. You can today they automatically give you extensions if the process in the patent office has taken an unreasonably long period of time. And sometimes in biotech they can be really slow, and when you patent issues, you'll see they'll add another year and a half to the term of your patent, which is helpful. And then if you have a patent on a drug and the FDA takes an unreasonably long period of time, you can actually apply for an extension of your patent to compensate you for the time that it was glommed up in the FDA. So how does a company benefit from a patent? Well, the market exclusivity that they get justifies big investments. They might have to build a factory to make this new drug. They're going to have to hire a new sales force. They had to pay a lot of money to get do all these clinical trials and go through the FDA approval process. And so knowing that their competitors won't be able to sell the same drug, and they'll have the market for that improved drug all to themselves for a while, justifies spending that money. On the other hand, sometimes companies patent things because they have a product that's already making them a lot of money, and they come up with some alternative ways or alternative drugs, and they say, we don't want anybody selling these alternatives because we don't want them to be able to beat us in the marketplace, so we'll get patents on those and use them to block people from making competing products. And that's a perfectly valid thing to do. And sometimes if you have a patented product, it might not be that big a deal. It may not be that important a product. Maybe you have a catalog that has 200 things in it and you have 2 patented products. Maybe one's a little flask shaker, and one's a little addition that you can put on your GC mass spec. But if people come and you're the only ones who sell that particular cool little product, they may buy other things from your catalog while they're there, get to know you and trust your company, and so it can help drive your sales of other products. Patents are often licensed. It's basically the same concept as giving somebody a lease to an apartment. You're allowing them to make, use, offer for sale, sell, and or import the patented article. And they pay you a royalty, which is usually some kind of a percentage of what they earn. And maybe some other fixed payments is usually some money up front. And maybe when they get FDA approval, they might make you a big payment, something like that. And it's not just academic institutions that do this. Big companies do this too. I met a guy not too long ago who was involved in licensing inventions for Thomson Electronics. And he said their out-licensing division had 600 employees. And 450 of their employees were engineers. In fact, they referred to them as reverse engineers. And what they did is they got all of their competitors' products and they took them apart. And they worked with patent lawyers to figure out if any of the competitors' products were infringing any of their patents. And then when they would find some little doodad inside this printer that infringes one of their patents, they would go knock on Sony's door and say, you know, you have this printer and we found that there's this patent that's infringed. And to tell you the truth, we have 380 patents on printers, and we're pretty sure there's probably some more in here in our printer portfolio that you'd probably want to take a license to too. So how about if we just license them all to you for a certain amount of money? And so they make a lot of money doing that. And you may remember Texas Instruments years ago. They had some of the first patents on integrated circuits. And sure, they made some products, calculators and things themselves, but they made way more money on licensing their semiconductor patents to other companies than they did in selling their own products. Okay, patents are limited monopolies. There are some things you're not allowed to do. So you can't say, I'll give you a license to my machine for making cloth, provided that you buy all your thread from me. That's called tying, and it violates the antitrust laws. And patent misuse is another claim that someone might make if they sued you for doing that. And if you're found guilty of patent misuse, then the court will refuse to enforce your patent, and your patent is essentially useless. You cannot require people to pay royalties after your patent expires. Even if there's a very famous Supreme Court case where John Deere Company had a bunch of patents on tractors, and they said, gee, you know, the average farmer couldn't possibly afford to pay us the royalties on all of these valuable patents. So we'll sell you the tractor and we'll charge you royalties for 20 years, even though our patent's only going to last for another 10, because you couldn't afford to pay that much in just 10 years. The Supreme Court said you can't do that. Once a patent expires, it's against public policy to allow you to collect another penny. You can't require people in exchange for a license to agree not to sell competing products. You can't force them to license patents that they don't want. You can't say, well, you're infringing this one patent, but you have to license all 600. You have to be willing to license them just the one. You can't force your licensees to charge a particular price for the product. And you can't restrict if you license your patent to a company and they sell the products to somebody, you can't control what the ultimate buyer of the product does with them after that. All of these things would give the patent owner more power than the patent laws intend, and governments generally abhor monopolies because they restrain trade, and so there's strict limits on how far you can push the patent monopoly. If you make, use, offer to sell, or sell a patented article in the U.S., you are a direct infringer. If you encourage somebody else to do so, then you're inducing infringement. In other words, for example, if you might say, well, this generic drug, you can actually use it to treat cancer. Well, maybe there's a patent on a method of using that drug to treat cancer. And if you encourage people to do that as a way of selling that drug, then you're guilty of inducing infringement, and you're just as guilty as if you were the infringer yourself. Or if there's a machine that is patented, and you have a particular part, and you know that if you add that part to this machine, it's going to make that machine infringe the patent. If you sell that part, you are a contributory infringer, and you're just as liable as if you were a direct infringer. Infringement lawsuits, unfortunately, the only way you can protect your patent rights. Remember, a patent gives you the right to exclude others from using your invention. Well, the only way you can do that is to sue them for infringement. And the first thing that happens is there's papers going back and forth, sometimes for years, and then eventually a judge has a Markman hearing and interprets the meaning of your patent. The statements at the end are called the claims, and that defines the scope of your monopoly, and the judge will interpret the words and describe what those words mean and set out a series of instructions for the jury. Most of these are jury trials, tried to average people. This case that I worked on with Johns Hopkins, we had a jury of 6 housewives, none of whom had more than a high school education, and we're explaining to them how to make monoclonal antibodies and use them in antibody affinity columns to purify stem cells for bone marrow transplants. It was quite a challenge. The legal fees are ridiculous. It's very easy to spend $5 million defending your patent today. But if it's a valuable invention, it can be worth it. If you win, you'll get reasonable royalty damages. You'll get a percentage of the infringer's sales, such as you would have gotten if you had given them a license before they started to infringe. And you could also get so-called lost profits damages. The court will assume if you were manufacturing and selling the product, and then along comes the infringer, and maybe your profit margin is 50%. And maybe the reasonable royalty damages is only 5%. But if they hadn't been selling the infringing product, you would have sold that product and you would have made the 50. Well, the court will make them pay you the 50. And then if you can convince the court that they knew about your patent and they infringed it anyway, the judge can triple your damages. And then, most dramatic of all, you can get an injunction, which basically is a court order where the court says that the infringer can no longer manufacture or sell that product. And if they do, the CEO and the board of directors are all going to jail, which usually puts an end to it, which is a very valuable part of a litigation. And sometimes cases will get settled because they would really rather get a license than be put out of business. The vast majority, probably better than 98% of patent cases settle somewhere along this process because of its expense. Okay, so that's kind of a quick run through the patent world. Yeah. Attorney's fees in the United States generally, everybody pays their own attorney's fees unless there are exceptional circumstances. If the behavior of the infringer was especially egregious, if they raised frivolous arguments, then you might get an award of attorney's fees. In Europe, however, attorney's fees are always paid by the loser. So if you sue somebody in England and you lose, you're going to not only have wasted your own attorney's fees, you're going to have to pay their costs as well. There's been a lot of talk about using that system here. Texas has recently adopted a loser pays system for certain kinds of cases.
Before we move on to copyright, just one more thing about patents. So, building on the thing about someone taking a picture of my poster, if I give a talk and I don't hand out materials, that's considered not published. But those talks are usually videotaped and posted on the internet.
Oh, then it's published, absolutely. Yeah.
Okay, so
Yeah. Oh, yeah. That's publication, yeah. Oh, grant applications. A grant application is considered confidential until you get a notice of award. Then it becomes available through the Freedom of Information Act, and therefore it's considered a public document. So you can send in a grant application, and if you're pretty sure what the review cycle is, you may have time to file a patent application after you send it in, but you're better off to try to plan ahead a little bit. The other thing is almost every RFP has a provision that says if there are trade secrets you'll need to disclose, then put those on a special page and right at the top, confidential. And if there ever is a Freedom of Information Act request, we won't send them those pages. So you could do that if you're worried about, you don't have time, you didn't think ahead about filing a patent application, but you want to make sure that somehow it doesn't get published or become publicly available before you have a chance to file a patent application. Yeah.
With a patent, usually who can file the patent? The inventor itself or the organization who invents it all?
Under U.S. law, all patents originally belong to the inventors. Different countries have different rules. All of you who work at the Salk Institute signed a little piece of paper when you first came to work here saying that you were turning over ownership of all of your inventions to the Salk Institute. And the same is true of anybody who goes to work for a company signs a similar obligation. The only difference is if you work in academia, part of the deal is you get a share of the royalties. And if you go to work for a company, part of the deal is that you get to continue working there. So, different rules. But it really is a matter of contract law, the reason why you have to give the inventions to the Salk Institute.
Filing the patents, you don't, I mean, there's an inventor, you don't have to worry about it.
Yeah, if you make an invention, the only question is whether you have an obligation, a contractual obligation, to give the ownership of the invention to your employer or not. If you don't, if you were to invent some new stage lighting for a theater, and you're working at the Salk Institute, well, that's going to be outside of the scope, unless you're the projectionist. That's outside the scope of your job function, and so yeah, you could go patent that yourself.
I mean, if we have some invention and we don't file a patent and then somebody just reads the article and decides to patent it, we then come back and say that was my invention and file a patent. And they just read the literature and file patents on everything.
If somebody reads literature and files a patent application on it, then it's not, then it will be lack novelty, because they're not the original inventor. There's actually a separate section of the patent statute that says that you're not entitled to patent if you're not the actual inventor. Okay, let's shift over to copyrights. This is kind of new territory. Copyrights cover original works of authorship, which can be literature, music and lyrics, plays, play scripts, pantomimes, pictures, sculptures, motion pictures, sound recordings, architectural works, and computer software. Anything that can be written, or these days can be stored on a thumb drive or a hard disk, is subject to protection under the copyright laws. In fact, a couple of you are jotting down notes as we're going along here. Your notes are copyrightable as well. In fact, they're protected by the copyright laws as you write. Copyrights have to be only cover things that are fixed in a tangible medium of expression, such as your notebook. Once they're fixed, they're protected under the copyright law. However, copyrights do not cover any ideas, procedures, processes, systems, methods of operation, concepts, principles, or discoveries. A lot of these things are protectable under patent law, except ideas per se, such as E equals MC squared, are not protectable at all. They belong to everyone. Copyright subsists from the very moment of creation. So when you're taking notes, your copyright in those notes exists as you write them. And for things like the notes you may be taking, the copyright on your notes is good for your entire lifetime plus 70 years. So make sure you leave those notes to your heirs, and if they turn out to be really valuable, they'll be able to benefit from that. So, and so for example, this has been important for, one that comes to my mind is Jimi Hendrix's family has been very active in policing and capitalizing upon Jimi Hendrix's original recordings. They've released them many times, and because it lasts for 70 years after his death, that gave a lot of value to his heirs. For works for hire, which would include anything that you might write in your official duties for the Salk Institute, or things that you, say a book that's written by someone anonymously or under a false name, such as Mark Twain, those works are valid for 120 years from their creation, or 95 years from the first publication, whichever's first. So copyrights last a real long time. And the term of copyrights has slowly been getting longer. There was a time when copyrights were much shorter. There were a time when copyrights had to be renewed on a regular schedule of every so many years. The movie It's a Wonderful Life, you see it how many times at Christmas time now? You see it on so many different stations. And the reason is the copyright ran out. Somebody forgot to renew the copyright on that movie until it was too late. It was a big lawsuit over it. They tried to do it after they discovered their error, and it didn't happen. You go to Chili's restaurant now, they sing the real Happy Birthday song. For a long time, they had some cockamamie song they would sing. And the reason they can sing Happy Birthday to You is because the copyright on that song has now expired. Your rights under the copyright law, if it's a, let's say it's a book or a manuscript or a recording of some kind, a DVD, a CD, an MP3 file, you have the right to reproduce it. You have the right to prepare derivative works. So, for example, the copyright, the author of the Harry Potter novel #1 had the right to make a sequel. It would be a derivative work. It was drawing upon the original, may have contained some excerpts from the original. Sometimes you'll see derivative works will be in the form of new editions, like a textbook. You might have a textbook that comes out, and then 5 years later, edition #2 comes out. Well, that's a derivative work because it contains almost everything from the original, and then they've added to it those things that have been discovered and understood since then. You have the right to distribute copies or phone records by sale, rental, lease, or lending. You have the right to perform the work publicly. So you have the right to show your movie. You have the right to play your song. And you have the right to display the work publicly, such as photographs and sculpture. Now, you've perhaps seen copyright notices on things. It used to be that the copyright notice was required. And if you didn't have a notice on it, that you didn't get any copyrights and you couldn't sue someone for copyright infringement. That got changed back in the 90s when the United States joined the Berne Convention for the International Protection of Copyrightable Works. And the Berne Convention was already 100 years old, and the United States was the last country in the world to join. And one of the reasons is that it required that copyright notice be optional rather than required. So it serves as a no trespassing sign. If you look in any book, you're going to see a copyright notice on the cover page. When you did your PhD thesis, you probably put a copyright notice in there. You will, and it can be written several ways. Very often it would be the C in the circle, the year, and the name of the owner, where you can write out the words copyright or abbreviate it COPR. There are some countries in which you might want to say all rights reserved, where there are certain limitations on your rights unless you say that. That is becoming less and less of an issue since the Generalized Agreements on Tariff and Trade, which is part of the creation of the World Trade Organization, which most developed countries belong to today. They had certain intellectual property standards that all of the WTO countries have to follow, and some of those related to copyright. So things have become more uniform since then. Copyright registration is you register with the U.S. Copyright Office in Washington, D.C. It's not required. Your copyright exists from the moment you create your work. But if you want to sue somebody for infringement, you have to file the registration before you do so. It's a real advantage. If you think you have something of value, it's a real advantage to file your copyright registration before you think someone might infringe. Because if you do, you can get so-called statutory damages of up to $200,000 and an award of attorney's fees. But if you wait until after there's an infringement before you file your registration, you're going to have to prove that you lost money by them infringing your copyright, and that may not be so easy to do, particularly if it's your PhD thesis and how you're going to prove you lost money from that. But if you filed your copyright registration and then you find somebody has reprinted your fabulous background section without your permission, well, then you could collect statutory damages. Yeah.
Would this work on like a blog where would you copyright just the compares to the blog, or would you have to copyright every time that you update?
On a blog, you would probably, there are a variety of different formats of copyright applications, and one of them is for periodicals, where you essentially just send in an update on some regular basis. You probably do that. So you would put a single notice on your blog, and then you would basically you can send it in electronically today. You would send in a copy of everything that's on it. And maybe if you thought it was a lot of valuable stuff, you might decide to do that every week or every month or every 3 months, whatever, and just make a habit out of sending them in so that odds are you'll always be one step ahead of the infringers.
So what about the review figure that I've published? That grants, is that my copyright? Is it the institute's? Is it the journal's?
You caught me off guard because I haven't really looked at the Salk copyright policy, but generally, academic institutions don't claim copyrights in scholarly works. The journal generally will. So when you go to publish something in Nature, they're probably going to have you sign an assignment saying that that you're giving them the right to reproduce it and publish it and reproduce it. In Science magazine, for example, they very often sell reprints. So they don't really want you going into the reprint business. They save that for themselves for things that are of general interest. How to register a copyright? It's actually very simple. Unlike a patent where you're going to have to hire a lawyer and spend $10,000 or more, copyright registration is very simple. And it's a 2-page mail-in form, or you can just register it online through the Eco Online system. And thanks to Rachel Mullen, who's here somewhere, she recently did some copyright registrations for us here at the Salk Institute. And I had not seen this system used before. You have to send 2 copies of most works. One is for a permanent deposit, so if there's ever an infringement question, they can get a copy of it. And another one is for the Library of Congress. The Library of Congress is supposed to get a copy of every copyright registered work in the United States. You can go to the Copyright Office and look at any copyrighted work, anything where there's a copyright registration. And you can take notes, but you may not make a copy unless you get permission from the copyright owner. And it's cheap insurance. You can file a new, as I say, you can file a new registration on each new version or edition, or just do so periodically for a blog or newsletter. There's special rules for music. It's kind of interesting. So they have compulsory licensing. So the Beatles, for example, had some real great hits. And what if there's a band, a local band, that wants to play some Beatles songs? Well, they're allowed to do that. The Beatles can't stop them because of the compulsory licensing that they'll have to pay a royalty, but they'll be allowed to play all those good old Beatles songs. And the royalty is determined by a royalty judge who decides how much each song is worth when it's sung. The normal being about 5% of whatever the purse is for the band playing that night. If someone plays a radio in a restaurant, they have to pay royalties on the playing of those songs. Because when songs are broadcast over the radio, they're only broadcast for personal use. There was a very famous case in Newark, New Jersey. There was a guy who owned a little dive bar, and he had a radio sitting on the back counter. And that radio had been on for 25 years. And one day, a fellow from ASCAP, the American Society of Composers, Authors, and Publishers, comes in and says, I see you're playing music on the radio there. I said, yeah, what about it? He says, well, you have to pay royalties to ASCAP so that we can divvy up the royalties with all of the composers of those songs. And the guy said, you're out of your mind. Get out of here. Well, ASCAP sued him, and he fought it, and he basically bet the bar and lost. And between the attorney's fees he racked up and the damages that were ultimately awarded for his infringement of all those copyrighted songs, he lost his bar. So when you go to the mall and you hear the background music, they're paying royalties to be allowed to broadcast that. It's all calculated statistically. Now, if you go to some place like the Belly Up Club in Solano Beach, you may see on the door a sticker that says ASCAP, because that's basically to show that they've paid they're paying their royalties to ASCAP. And so if any ASCAP folks happen to wander into the Belly Up Club, they're going to say, oh, they're taken care of. Oh, and the other thing I just realized, and this is something I had never known before, registered sound recordings are designated by not the C in a circle, but by P in a circle. I haven't actually seen that on a record, but I'm going to look for that now, or on a record, on a CD. There are a number of specialty copyrights that are kind of interesting. There's one called mask work, and that covers the three-dimensional pattern that's inside a semiconductor chip, like a CPU unit or a memory stick. And the cost of creating a new CPU, by Intel, is measured in millions of man-hours that go into the design of that integrated circuit design. And so they get a special protection called a mask work protection. They register the details of their design, and that protection lasts for 10 years. And then if AMD comes out with a chip that's just as powerful, they can go take one of those apart and see if they have a mask work infringement. And the symbol for mask work protection is M in a circle. I've never seen one of those either. In architecture, if someone creates a beautiful work of architecture and they can license the design, you could actually go, and if you say there might be I've seen some very interesting eco-friendly modular housing designs, and you can go and you can buy a copy of the architectural blueprints that give you permission to build one house. And if you build two houses, you're an infringer, and the remedy for your infringement is the court will order the second house bulldozed. Needless to say, you want to make sure you buy a copy of the plans for each one that you might want to build. But on a famous building, you might never be able to convince somebody to give you a license to copy a famous building. Such as the Salk Institute. I would assume that the Salk Institute was built in the 60s, and we said copyrights last a pretty long time, right? So the copyright on the Salk Institute is still in effect. So no one could actually go and build a replica of the Salk Institute somewhere without infringing our copyrights in the architectural design. And then, but you can take pictures of the Salk Institute all day long. That won't infringe the copyright on the building. Boat hulls, boat decks, and the molds to make them are covered by special registration, often referred to as a plug mold protection. The design has to be original. It can't be dictated entirely by function. It has to have an ornamental dimension to it, and protection lasts 10 years. And the reason for this is it's very easy to take a boat, slather it with some grease, put some fiberglass around the outside of it. Now you have yourself a mold, and then you can reverse the process and make some more boats. So very easy to copy boat hulls, and that's why they have their own special protection. There is an exception to copyright infringement called fair use. And fair use exempts certain acts from copyright infringement. So scholarship or research, if you copy something and hand it out to a class for them to discuss, to critique, then that could be fair use. It might not be copyright infringement. It's applied on a case-by-case basis, depending on whether your use was commercial or not. The nature of the work, was it the kind of work that's ordinarily used in teaching? How big a portion of it do you use? Now, I had a professor once who, there was a book that was out of print. It was a little paperback. He copied the whole book and handed it out. Obviously, that would not have been fair use because he copied the whole book. And the effect on the potential market for the original work. By photocopying that book and handing it out to us, we wouldn't want to go buy one, would we? The fact that it was out of print made it less of an issue. So sometimes there is such a thing as fair use, and a lot of scholarly activities come under that. Copyright infringement lawsuits, the central issue is you have to prove that they derived their work from yours. So it's often very clear-cut if somebody makes a unauthorized MP3 files, downloads music from some bootleg website. It won't be too hard to show that those are your songs that are covered by the copyrights to your composers and artists. But sometimes it's complicated. A woman by the name of Sophia Stewart sued Warner Brothers and 20th Century Fox, saying she had written a 41-page story called The Third Eye, and she was convinced that the movies Terminator and The Matrix were based on her short story. And it was a big deal. And ultimately, when the court date came up, she failed to appear, and the case was dismissed. Why she didn't show up, who knows? The 1971 Beatles hit My Sweet Lord was found to infringe the 1962 Chiffon song He's So Fine. If you listen to these two songs, you will go, huh? And what's strange about it is, in the part in the Chiffon song where the vocals are, in the Beatles song is silent, and where there's no vocal in the Chiffon song, that's where the lyrics are in the Beatles song. So you have to listen to them without listen to just the music and take the singing out of it to hear it. But they said, well, John Lennon didn't really mean to steal the Chiffon song. It was subconscious copying, so the damages were pretty light. Okay, that's copyrights. Trademarks are yet a third kind of intellectual property protection. A trademark is generally a word, phrase, symbol, design, or a slogan, or some combination. Its sole purpose is to identify and distinguish the source of goods and services. So, for example, this little picture here is a trademark of the Salk Institute. The word Salk Institute is a trademark owned by the Salk Institute. And we have trademark registrations on those. It distinguishes the source of goods or services. Here it distinguishes the particular spectacular science that goes on here. It's protectable under state law and under federal law. Under state law, you can just very easily just put a TM next to something. It serves as kind of a no trespassing sign and says, I consider this my mark of trade. And if someone infringes it, then you could sue them in state court for trademark infringement. Sometimes you'll see SM, which means service mark. Usually a slogan like, you deserve a break today. Who owns that? McDonald's. Yeah, McDonald's, of course. You deserve a break today. So you'll see service, and sometimes it's not worth going to the trouble of getting a federal trademark registration on some slogan that you're going to use in a marketing campaign for a short period of time. But you don't want your competitors to copy it. Now, generally, if you have a really important mark, you're going to file a federal trademark registration. And the federal registration, once you get it, you'll mark your products with the R in a circle to show that you have a federally registered trademark. One of the funny things is that a federal registration is stronger than a state trademark claim. So if I open up Guido's Pizza in La Jolla and I put TM next to my sign, that's my mark of trade, then I find out that that some big company is now opening up Guido's Pizzas all over the Southwest, and they got a federal trademark registration on Guido's Pizza. I'm out of luck. I'm still going to be allowed to use Guido's Pizza as my mark in La Jolla and maybe in San Diego. But everywhere else in the country belongs to the other guys. So it's always worthwhile to file a federal trademark registration if you have any plans of expanding your business beyond your current location. There are lots of very well-known trademarks: McDonald's, Walmart, IBM, GM, Marriott, Delta. I mean, the list just goes on. The golden arches. You see the golden arches, you know that's McDonald's. You don't have to wait until you read the sign. And Apple with a bite out of it. Apple Computer. Remember when Apple Computer first came out, everybody goes, what the hell has an Apple got to do with a computer? Nobody asks that anymore. 5 interlocking rings. Yes, the Olympics, right? 2 overlapping R's. Anybody know what that is? Rolls Royce. Yeah. The greatest show on earth. Barnum and Bailey, right? All the world loves a Coke. The Big Apple. What's Up, Doc? And Got Milk. Those are all registered trademarks. And then there are also something called trade dress, such as the shape of the Heinz ketchup bottle or the shape of the original Coca-Cola bottle. If you were to sell ketchup or Coke or a cola in similar shaped containers, that would be considered trade dress infringement. There are also some unusual trademarks. So, for example, Owens Corning has a trademark on the color pink. Nobody else can make pink fiberglass home insulation other than the Owens Corning company. And that's why if you go down to Home Depot, you might see blue or yellow or green, but you're not going to see pink unless it's Owens Corning. AOL has a trademark on the sound of "You've got mail," the little sound that AOL makes when you get a new email. They have a trademark on that. The Aflac duck. They have a trademark on Aflac. Sound of a duck quacking like Aflac. They have a trademark on that. And then there's an embroidery company that has a trademark registration on a smell. Their thread has a very distinctive floral fragrance, and they have a trademark on it.
Now, what about perfumes? covered under patents and not trademarks?
Perfumes are generally protected as trade secrets. They don't tell anybody what the ingredients are, and you'll see in the stores, say, if you like Chanel No. 5, you'll like our CVS No. 5. And they get as close as they can, but it's never quite exactly the same. Somehow it doesn't have the same ring to it. A federal trademark registration is only granted if there's no likelihood of confusion. The mark has to be unique or have a secondary meaning, which I'll come to in a moment. And it only covers limited categories of goods and services. So if I were to, the trademark on the Salk Institute is probably registered for educational services, for scientific research services, and for T-shirts, sweatshirts, hats, and the like. Right? And that's typical for academic institutions. As I say, it trumps the state law rights of others. And you have to renew your trademark registration for every 5 years. And you would only bother to do this for important marks that you think are going to have some long-term value. Otherwise, you just rely on the state laws. It's not cheap. There are fees to pay, plus the attorney fees. You can go to the PTO website, Patent and Trademark Office website, and get the forms and do it yourself. But you have some challenges figuring out what classes and subclasses. And the forms are simple, the rules are complicated, and usually you're better off to just hire a trademark lawyer. Before you adopt a trademark, you need to do a search. There's a registry at the Patent and Trademark Office. So if you decide you want to start a company or you want to start a local jazz band, it's a good idea to, when you come up with a name, go do a search and see if it's available. It's a company called Thompson & Thompson. It's been around forever. That does trademark searches, and they search all over the world in a variety of ways. And usually, if it's out there, Thompson & Thompson will find it. So if it's an important mark to you, it's worth it to get them to do a search. You have to consider the likelihood of confusion. How close is it to somebody else's mark? If there are other marks that are close, you have to look to see whether they're active or whether the marks have expired. If they've expired, you may be able to use them. And if there's a mark that's something that's close, you might ask them for a concurrent use agreement. When I was at Rutgers University, we handled their trademark licensing for T-shirts and sweatshirts and things. And it was a high school, and the mascot is the Scarlet Knights. Well, there was a high school in Rhode Island that decided they were going to have the Scarlet Knights mascot. And we ended up giving them a concurrent use agreement, allowing them to do that so long as they also printed the name of their school on the T-shirts and sweatshirts. Pick your marks carefully. Bad marks can be really expensive in the long run. People accusing you of trademark infringement. If you get a letter from McDonald's saying that they think you're infringing one of your trademarks, then you're probably going to change your mark rather than have to fight them. And it can cost you money and goodwill. If you've started your band and you have this great name and now you got to change it, people are going to think your band went belly up when actually it didn't. Remember that changing the wording doesn't matter. So if you use somebody else's mark but you change the wording, think about how it's going to sound when they mention it on the radio. It's still going to infringe. You want to pick a few marks and live with them for a while, like for a couple weeks, and figure out which ones really sound good to you over the long term. And then watch out for unintended meanings. Chevrolet company had a very popular car design in the United States called the Nova. But in Spanish, that means no-go. And they wondered why their sales in South America were so bad. Well, they rebranded it for South America. This is kind of fun. There are 4 kinds of trademarks. The most common one is called descriptive. So like International Business Machines, IBM. When they first went to register that mark, the trademark office would have said, I'm sorry, that's merely descriptive of your business. It doesn't indicate a particular international business machine company. It's just describing the business you're in, the kinds of goods you sell. Now, there are 2 ways to prove that your mark has secondary meaning. One is you can go out and do a man-on-the-street survey and you walk up to people and say, when you hear the word name International Business Machines, who do you think of? Oh, I think the IBM company down the street. And you get enough of that testimony, then you can get your registration. The other thing you can do is just use it in commerce for 5 years, and then the trademark office will assume it has acquired secondary meaning and that people really do relate it to your company. But descriptive marks don't tend to be the strongest ones unless they're very famous ones like IBM. Then there are suggestive marks, such as one of my favorite suggestive mark is chrysalis records. The chrysalis is the butterfly emerging from the cocoon. So it evokes a very positive image. But there's also chrysalis bicycles. There's the chrysalis auto repair. I mean, you name it. Everybody has used the word chrysalis for something. So there's just not that many of those words around. And there are other suggestive words that evoke something positive, but they tend to get used pretty heavily. Then there's arbitrary marks, which can be very strong, such as Apple Computer. As I say, when Apple Computer first came along, everybody goes, what the heck's a computer got to do with an apple? But it was a very distinctive mark and it stuck, you know. And other people have tried to come along with peach computers and stuff like that. It never really worked out. But Apple stuck, you know. The strongest marks are called fanciful marks. And it's basically a made-up word. When the old Esso Corporation decided to rebrand itself, they wanted a word that was reminiscent of the old Esso, ESSO mark, but something that was a little bit snappier, a little more modern. And so they came up with the word Exxon. And at the time, it had no meaning in any language in any country of the world. And there was only one company that used the name Exxon. It was Mr. Exxon owned a hardware store in Nebraska. And the Esso Corporation bought the hardware store so that they could have the mark. Since then, the word Exxon has taken on a meaning in biotechnology, but that hasn't done anything to dilute the fact that if you see Exxon on a sign going down the street, you darn well know it's a gas station. Trademark marking, you can use TM or SIM anytime you want to. You don't have to get any permission. You can only use the R in a circle after your federal registration has issued. It's illegal to use the R in a circle unless you have a federal registration. You can actually be sued for damages for that. And if you look at the way you want to see how they're used, just look at the way companies like McDonald's and Microsoft use the R in a circle. Infringement. The most common kind of infringement of a trademark is called passing off. And there are 4 varieties of passing off. There's express passing off. That's what somebody offers in the park to sell you a Rolex for $50. You're pretty sure that's not a real Rolex. It just says Rolex on it. That's a knockoff. That's express passing off. Or sometimes a restaurant will have Heinz ketchup bottles on the tables in the restaurant, and they're actually refilling those bottles from some big vat they've got in the back of brand X ketchup. That would also be passing off. They're passing off their cheap ketchup as Heinz ketchup. Then there's implied passing off. This is something, you know, if you go to a restaurant now and you say, let me have a Coke, they go, we don't have Coke. Is a Pepsi all right? You know, yeah, sure. I mean, the reason they're doing that is because they got sued by Coke. Coke hired an army of lawyers to go out and order a Coke at all kinds of places that they knew only sold Pepsi products. And they say, oh, let me have a Coke with that. And, you know, and they get their burger and they get a nice cola. And the lawyer would say, you know, could I speak to the manager? And then they would give the manager a lawsuit complaint. Say, we're suing you for trademark infringement because I asked for a Coke and you gave me a Pepsi. And you're passing off this inferior Pepsi product as a Coca-Cola. You can't do that. And so that's why. And then Pepsi did the same thing. Oh, we don't want people passing off that inferior Coke product as Pepsi. And so that's why they always ask you now if the other product is okay. And then there's reverse passing off. So express reverse passing off would be if Sears were to take Wrangler jeans, take the Wrangler label off and put Sears labels on. That's express reverse passing off. They're taking the superior product and putting their mark on it and claiming that it came from them when really it came from the Wrangler company. And then there's implied reverse passing off. That would be if Sears took the Wrangler label off, didn't have any label on them, but they sold them in their Sears stores. And in fact, implied reverse passing off, most courts will refuse to find you liable for it. If they want to take the labels off stuff, then they can do that. But the other three, you can actually get sued for. There are other kinds of trademark lawsuits. Trade dress infringement. Big trade dress infringement case was had to do with the Act mouthwash, where people were selling, CVS and others were selling anti-plaque mouthwash in bottles that were identical to the bottles that Act mouthwash came in. They had different labels, but it was the same color, the same shape, and that was a big lawsuit. And then there's dilution of famous trademarks. So if there's a famous trademark like McDonald's, there was a gas station in New Jersey. It was called McGas. Now, McDonald's doesn't sell gasoline. Everybody knows that. But the McDonald's mark is so famous that they have an unlimited zone of expansion into other goods. And so the courts recognize that as blurring. It would blur the mark. People would be confused because they wouldn't be quite sure whether McDonald's went into the gas station business or not. And so that would be, they'd be liable for that. Or if somebody started selling Kodak shoes, well, did the Kodak company start selling shoes? They'd be confused about where those goods really came from. And then there's tarnishment of a famous mark. Using it in an unwholesome or unsavory way. There's a very famous case where a company called Victor's Little Secret sold X-rated goods and attire, and the Victoria's Secret company sued them for trademark tarnishment. They said, we have a very respectable and famous brand, and he's selling tawdry goods and tarnishing our mark. And they got an injunction against that. And lastly, and we'll wrap this up pretty quickly, trade secrets. The last flavor of intellectual property protection is trade secrets. The California Uniform Trade Secrets Act, and every state has similar language, defines a trade secret to mean information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to the public or to other persons who can obtain economic value from its disclosure or use, and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So if you have a, let's say I have a drug company and we sell this particular drug, and we have a particular process for manufacturing the drug. It's not a patented process. We just don't tell anybody about it. And no one else is allowed to know. We make our employees sign secrecy agreements, and the formula for how to make it, the procedure for making it never leaves the building. And if someone were to take that, then they would be guilty of misappropriation of trade secrets, and I could sue them for it. Of course, you have to keep it secret. You have to use reasonable means. So, for example, employment agreements that say your employees aren't allowed to reveal these things. If you need to tell someone, let's say you have a supplier, you need to tell them that you need to buy some materials, you might ask them to sign a confidentiality agreement because you don't want to reveal anything about your manufacturing process. You would have areas that you only allow employees into, so they have to use a magnetic key card to get into the company. You have a front desk where visitors have to come, and visitors always have to be escorted through the building so they can't walk off with any secrets. You keep certain things in locked file cabinets or safes. And one of the other things you do is when you have employees who leave to take a job somewhere else, you have an exit interview with them and you point out to them that you signed a trade secret agreement with us, that you had agreed to keep all of our processes confidential, and we consider the methods of manufacture of A, B, and C to be highly valuable to our company. And if you tell your new employer how we do it, then we're going to come sue you. These are all things that you can do to maintain secrecy. There are risks and benefits. The problem with trade secrets is reverse engineering is fair game. So if you have a product that somebody can figure out, let's say it's a computer chip, if somebody can figure out how to make that computer chip by getting some and taking them apart, then trade secret protection is doing you not much good. If you have a product like that, then you're much better off to have a patent, or in the case of a computer chip, perhaps a mask work copyright. Trade secrets can kind of bleed out over time. Nobody may run off and tell their competitors about how you do things, but very often people will disclose little bits and pieces. And if Intel's been hiring AMD employees on a regular basis over 20 years, you can be pretty sure they know a lot about how AMD works, and no one person told them very much. But if it's well protected, they can last forever. The most famous trade secret of all is the formula for Coca-Cola. The key flavor ingredient in Coca-Cola is called merchandise 7X. It's a concentrated material that then gets put into giant vats of Coke when they make it. And the formula for merchandise 7X is kept in a vault in Atlanta, Georgia at their headquarters. There are only 2 executives who know the formula. Some people say that each one only knows half of it, and they're never allowed to travel together. They say factory workers who produce this merchandise 7X are rotated frequently. Very rarely does somebody make it more than once. And they may come in and add a pound of this, and then they send them out, bring another employee in to add the next 2 ingredients. Until 1991, you couldn't buy Coca-Cola in India because old Indian laws required that all trade secret information be disclosed. So they said, well, then we're just not going to sell Coca-Cola there. The secret has been kept since 1886. And you will read, or I read an article, it was about a month ago, I saw an article, the formula for Coca-Cola has been revealed. And somebody once again claiming that they now knew the formula for Coca-Cola. Many people know what the other ingredients are. They just don't know what's in this 7X stuff. And, somebody had revealed it. And you can go and you can look in books and you'll find, or go online and Google formula for Coke. You'll find people who tell you exactly how to make Coca-Cola. But every account I've ever read, they said, if you make it, it's not going to taste like Coca-Cola. That It may get close. It may taste similar, but it's not going to taste exactly like Coca-Cola unless it came out of a Coca-Cola bottle. And that's exactly the way they want it. Trade secret lawsuits seek to block or remedy misappropriation. Common cases would be somebody works for a hairdresser, and then they go take a job with a hairdresser down the street, and they bring their customer list with them and all the phone numbers. That would be misappropriation of trade secrets. I was involved in a trade secret case once where the vice president for research of our client's company quit, and 3 weeks later, turned out he was appointed vice president for research at our arch competitor and working on an identical project. And we actually got an injunction against him taking that job. Computer geeks go from Apple to work at Google. And if they're working on a particular similar project, someone Apple might sue to try and stop them from going to take that job. Usually an injunction is the primary remedy. Basically a court order saying if you go work there, we're going to put you in jail. The focal question becomes, well, if you have general knowledge and experience, well, you can always bring that to your next job. That's not a problem. It's if you bring specific pieces of information. It's not that, well, whenever you mix dry ingredients and wet ones, you always want to add the powder to the water. That might be a general knowledge. But to say, well, when they make Coke, they add the water to the dry ingredients, that would be specific knowledge that you're not supposed to disclose. Now, some states, they can stop you from taking a job with a competitor if they convince the court that it is inevitable that you are going to reveal trade secrets. You are up to your eyeballs in trade secrets at company A, and now you're going to go to work for their competitor. It's inevitable that you'll disclose to them secrets of company A. The California courts refuse to acknowledge that any disclosure is inevitable. You have to prove an actual risk or an actual occurrence. And so that's it. So that is the 4 flavors of intellectual property: patents, copyrights, trademarks, and trade secrets. And if you can try to remember the differences between them, and remember that all of them can have value in different circumstances. One of these talks we're going to talk at one point about starting companies, and certainly when you start a technology company, you're going to need to pay attention to all 4 of these and use that to develop an intellectual property strategy for the protection of your business interests. Okay, well, thank you for coming.